Right. A very good afternoon, ladies and gentlemen. Welcome to the month of February, the month of love. And what better way to start this month of love than start with a conversation that is so dear to us all as legal practitioners. And that conversation is a conversation that many of us young lawyers do grapple with, and that is speaking with confidence as a young lawyer. And just like any other lawyer who steps into court for the first time, you're always nervous entering into that court premise. I do remember my very first court appearance, very nervous, and could barely say a word after practicing the whole night. And eventually, I happened to gain the audacity, or rather, the energy to speak before the magistrate then. And this webinar today really seeks to emphasize not only substantive law, but procedure rules, and it will help us look at the psychology of advocacy, things like voice projection, narrative framing, and performance under pressure. And we have quite an estimable list of panelists as they will be introduced at a later stage. But at this juncture, I would like to welcome you all on behalf of our CEO, Mr. David Sigana, our President, Mr. Ramadan Abubakar, and to say thank you for making time to join this very wonderful session that we have the most singular honor of having a very estimable gentleman to moderate this conversation. Our moderator this afternoon is an advocate of the High Court of Kenya. And this gentleman, interestingly, is driven by an insane passion for becoming an outstanding advocate with key interests in human rights, commercial law, criminal conveyancing, among others. He currently works at Nduva Kitonga and Company Advocates, a member of our Young Lawyers Committee, and a very dear friend of mine, Mr. Otto Nduva. Good afternoon, Mr. Nduva from Nairobi.
Good afternoon, Gabriel. I'm doing well. How are you?
I'm doing very well. Our participants are here and our panelists are here. And now it's over to you, sir.
Thank you. Thank you.
But,
my colleague and brother. Yes.
But before you go, Mr. Nduva, perhaps in your introduction, how was your first court appearance?
My first court appearance. It's one that I'll never forget. So here it was. I had everything crammed up in my head, and I remember just as I was about to address court, I had a gadget malfunction, and that kind of distorted me. So I'm there trying to address the court. Your Honor, can you hear me? The court is like, no, I can't hear you. Luckily enough, the file was placed aside. And again, I had to recompose myself. And I learned from that, always make sure that your gadget is ready and expect the unexpected because anything can happen. But yeah, that's how it was.
Wow, I can imagine. Over to you, sir. You can take us through the session.
Okay. Good afternoon to my fellow colleagues across East Africa, wherever you are joining us today, from Burundi, from Ethiopia, from Kenya, from Rwanda, from South Sudan, from Tanganyika, from Zanzibar, and from Uganda. We young lawyers, we share one but quite powerful struggle. We know the law. We really know the law. But finding the confidence to speak about it boldly can be a different case altogether. And that's why we have this webinar today, curated by the East Africa Law Society. And like my brother said, Gabriel, many of us remember our first court appearance. And if you've not had your first court appearance, you're going to remember it. Because for most of us, we find that it's heart racing, our palms are sweating, our voice is betraying us at the very moment that we need it the most. But Or not. Today's webinar is a conversation, and it's a conversation about a journey from nervous to persuasive. Because ideally, every time you appear before the court, you appear the court to persuade it so that the court can rule in favor of your client. And today, we are very privileged to have an exceptional panel. And the panel consists of seasoned practitioners and thought leaders. And today's discussion is going to be crowned by a keynote address from a senior counsel who embodies what confidence, ethical, and persuasive advocacy looks like in practice. Again, to my young lawyers across East Africa, this is not just a webinar. This is a mentorship moment. This is a mirror and hopefully a turning point for every young lawyer who has ever doubted whether he or she belongs at the table. So today, I invite you kindly to take notes, to ask questions, and most importantly, to see yourself as the confident advocate you are becoming. So again, welcome to today's webinar, which is entitled From Nervous to Persuasive, How to Speak with Confidence as a Young Lawyer. So the next juncture that I'll take will be to introduce the panelists, and I'll introduce them and then they'll pass a brief hi, brief hello to everyone. And again, it is my honor to welcome our keynote speaker. He is a distinguished senior counsel, and his career exemplifies excellence in advocacy, professional presence, and ethical leadership. Senior Counsel Chacho Odero, you're most welcome. Kindly say hello to the audience.
Thank you very much for the warm welcome. I look forward to this engagement. Asante sana from Nairobi.
Thank you. And the next speaker, we have a speaker who will address building professional confidence and executive presence as a young lawyer in today's fast-paced legal practice and environment. We are delighted to have you, Elsie Michelle Irakoze. Kindly say hello to our audience.
Hello to the panelists and to the audience. Hi, bonjour from Burundi.
Thank you. Joining us as well is a speaker who will take us inside the mind of an advocate, exploring the psychology behind confidence and persuasive advocacy. Alex Ntale, you're most welcome. Please say hello to our audience.
Hello everyone, Alex Ntale here from Kampala, Uganda. I'm happy to speak on this webinar.
Thank you, Alex. Again, we also have another speaker who's focusing on the most visible aspects of confidence, voice, body language, and advocacy resilience. Debra Kambole, we're glad to have you with us. Kindly say hello. Debra Kambole. He will join us shortly. Again, we'll also hear from a speaker who will share practical, hard-earned lessons from the front lines of legal practice. And these are the things that many of us only learn in the hard way. So Timothy Lugayezi, welcome, and please greet our audience.
Good afternoon, everyone. I hope you can hear me.
Yes, we can hear you.
Yes. My name is Timothy Lugaizi Sempewa. I'm from Max Advocates in Uganda. I'm really happy to be here. As you can tell, Alex and I work in the same workplace, so it's a pleasure to have him here as well.
Okay, welcome. And lastly, we'll have a speaker who will speak to the confidence that's grounded in finding the authentic voice as a lawyer. So Crispus Mutabaza, you're most welcome. Please say hello to everyone.
Yeah, I hope you can hear me. Good afternoon to fellow panelists. Good afternoon to the audience. Pleasure to be here.
Welcome. Thank you. And now, to kickstart our conversation, I will take this moment to introduce our keynote speaker. He goes by the name Chacha Odero, Senior Counsel. And Mr. Chacha Odero, Senior Counsel, he is a senior partner at Oraro and Company Advocates and practices in the Dispute Resolution Practice Group. He has over 37 years of experience, and he has represented both local and international clients in commercial disputes, constitutional law, electoral disputes, employment and labor law, insolvency, and property law. So to the young advocates who are listening, to the young lawyers, we're about to hear from a very seasoned practitioner, Mr. Chacha Odera, Senior Counsel. He has been ranked by leading international legal directories such as Chambers and Partners and Legal 500 as a leading lawyer in dispute resolution and employment. Again, he has received quite the praise from the Kenyan legal community, and he has been termed as an extremely able advocate and gentleman in all manner of the word. Again, we're privileged to have him. He was also recognized as the overall lawyer by the Nairobi Legal Awards. It was hosted by the Law Society of Kenya, the Nairobi branch. Outside from his legal practice, Chacha Senior Counsel, he is an adjunct lecturer at the Strathmore Law School. He has been able to chair two ad hoc committees of the Law Society of Kenya, namely the Committee for In-House Counsel and the development of a comprehensive code of conduct for advocates. Again, we're delighted to have him. So a round of applause to our keynote speaker, Mr. Chacha Odera, Senior Counsel. Welcome.
Thank you, Otto. Thank you for that introduction. I'm humbled, and I'm especially humbled being invited to share my thoughts on this topic of today, which was communicated to me that I should speak about nervous persuasive, how to speak with confidence as a young lawyer. I still think I'm a young man in spite of having been in the practice for about 37 years, going 38. I am still young at heart, and I say so because I am still learning. I was once told that the day that you stop learning, that's the day you will retire. So for those people who we haven't met, we still have an opportunity to meet because I'm still learning and I will be around for a very long time. So just a little bit about myself to first of all talk about my journey before I dive into the core topic of this afternoon. In my early years, I was looking through my report cards, and these are report cards which my dad kept meticulously from 1970 right up to 1982. And one thing which consistently was a comment about me by my class teacher or by the housemaster, especially between 1970 and 1976, was constantly I was described as a shy person. Every time I tell people that I'm shy, they say, no, you can't be shy. But why am I sharing this story with you? I am sharing this story with you to encourage you that even in shyness, that is not a reason not to be able to communicate that which you ought to communicate. I went to University of Nairobi in 1984. And in fact, I was reminding my classmates that this day, 10th of February, 1985, it was a Sunday. We had a major riot at the University of Nairobi. And in the process, my hand was broken. I will not give the details of what where I was, how it was broken. But I think I found my voice that day that the police broke my hand in circumstances which I believe were extremely unfair. I got my voice then. And from that time, my wife always tells me I've never stopped talking. So I was admitted to the bar in 1988. And unlike many of you whose practice started from a virtual court appearance, mine between 1988 and the year 2000 was nothing but physical court appearance. My very first court appearance was the Court of Appeal. I do recall I had been helping my then boss prepare an appeal. And on the day of the appeal, which was the day after I was admitted to the bar, he didn't appear in the office. And of course, having a nervous client with me and the person who I'd always communicated with, we were both nervous as to how we will handle this crisis. I picked up the file together with the records of appeal, sauntered to the Court of Appeal, and praying and hoping that my boss will come and relieve me of the massacre I was about to go through. By the time the matter was called out, he hadn't come. And the matter was called out, and I had to stand up, introduce myself. And in our Court of Appeal then, there was no such thing as adjourning a matter. The judge would tell you, the judge presiding would tell you, put your show on the road. He wouldn't even ask you if you're ready to proceed. So, mastering all the courage that I could, I then started reading from some appeal notes that I had prepared for my boss, but which were of no help to him because he didn't come to court on that day. And during those days, the Court of Appeal was very interactive. It was not just a question of you placing your case, but you're constantly interrogated on the different scenarios or different arguments which one would advance with respect to the dispute at hand. At one particular point, I kept on quoting various decisions, reading passages from it, and the judges would tell me that, Mr. Odera, we know about that decision. Can you move on to your next point? And by telling me so, the effect of it was to derail me from the arguments, or rather from the script I had, which I'd intended to share with them by way of arguments. And what was my response to that? I do recall telling the late Justice Masime, Lords, I am aware that you know about these decisions. In fact, these decisions were decisions of this court. But we can never overemphasize the wisdom that spews out of these decisions. And the judges burst out laughing. So one of the judges then asked me, Mr. Odera, when were you admitted to the bar? Then I told them with a lot of confidence, I was admitted yesterday. So the judges burst out laughing. And they asked me, either you are very brave or you're very foolish to make your maiden appearance in our court. And I then answered that I choose to think that I am brave. And with that, my journey in courtroom litigation began. And I was years later instructed by some of those judges who saw me enter into litigation under the circumstances which I did. And one of those judges who came to instruct me on a personal matter told me he had never forgotten the courage that I exhibited, because either it would have built me or it would have destroyed my confidence. But I chose the former, that it would build me. So every generation has its own peculiar and unique challenges. And each of those generations are remembered how they faced and dealt with those respective challenges. During our time, when I first came in, I'm not sure whether there was a lot of time, but we were given all the time you require to argue our cases. And the arguments were played out by way of interrogation by the panel of judges or by a judge who would be hearing the matter. Today, the generation admitted in the last 6 or so years in Kenya are only used to a court on the virtual platform. And because of a program which has been put in place to raid the court of a backlog, they are given very limited time within which to put their arguments across. So, with the limited time you are given, one must be able to pack and package their arguments within that time which you have been given. And it has worked well, but on the other hand, it has also taken away from us the art of advocacy. In Kenya, typically, in the Court of Appeal or in the Supreme Court, you are expected to file your written arguments in advance, and on the day of hearing, you are only given 7 minutes within which to highlight your submissions. So, going beyond knowing the law, that will be my introduction to today's discussion. Many lawyers operate from the false assumption that confidence comes automatically with experience or mastery of legal principles. And I can speak to you with confidence because having been around for 37 years, I can tell you that what matters is not how long you have been at the bar. And when I say the bar, I use the bar as in the legal profession, not the other bar which we can meet later. Some people spend ages at the bar and many years later come out with nothing out the bar. Whereas we do have younger people who, taking advantage of all the time that they have in practice, they have been able to master confidence, to be able to sharpen their skills. They're able to scale up. They are well-read, they are meticulous, and they do not have to struggle after a couple of years of experience. And when do you start sharpening your skills, whether in preparation or whether in delivery of your arguments in court, or whether in gaining clients' confidence in meetings? The time to start is now. And every single brief ought to be, like a pilot says, every hour that you fly makes you a more qualified pilot. Similarly, we as lawyers, every brief you handle, every situation that you find yourself in, you should always look at it as an opportunity to be able to sharpen your skills and to get confidence, both of your client and of the court. So the difference between lawyers is not necessarily in intelligence. All of us, I presume, are intelligent. But the difference is the role that we play in leadership and in deliberate ability in advocacy. Every time that you are speaking in your professional capacity, you've got to always recognize that you're speaking on behalf of somebody else. And indeed, I've always told people that when you are doing something on behalf of somebody else, you need to do it better than how you do it for yourself. So confidence in the courtroom is not being the loudest in the room. It is often that calm authority which one exhibits in delivery. In the old days, especially in open court, there were lawyers who obviously the only language that they knew or the only ability that they exhibited is an abrasive ability. They are loud, they bang tables, and at the end of the day, they do not make any points. Because as a lawyer, you are persuading a judge or a magistrate who's a fellow lawyer. So you will not be able to confuse them with the noise that you're making. Indeed, I recall one time a judge mentioned to a lawyer that by raising his voice, it does not make his arguments more legitimate or more persuasive. So, as of necessity, one must be coherent. And even as you are coherent in your argument, those arguments must be based on both the law and the facts as can be discerned from the record. And as a lawyer, one of the things which you must always have is integrity, reliability, and you should be able to be a person who, when the judge listens to, the judge does not have to second guess as to whether you are telling them the truth or whether you are departing from the truth. In fact, there are some lawyers who, through my practice, if that lawyer died tonight and tomorrow somebody appeared in court and applied for an adjournment, that, my lord, I apply that this matter be taken out of the list because the lawyer who was handling it passed away last night. There are some lawyers who the judge will not even believe that they're telling the truth. And the judge may ask, how am I supposed to believe this guy died? I mean, his history has been one which has been riddled with a lot of departure from truth. So why am I sharing that story? I'm sharing that story so that you recognize that you are not your client's mouthpiece. When your client tells you to go to court and urge their case, do not go lying to the court or compromising on matters of integrity purely because you want to win your client's case. Because beyond that client, you will be required to address the court on various issues and sometimes even personal issues, which would require the court, in being persuaded, to look back at your own history. And if you're a person who has a history of integrity, you'll get away with it. But if you're a person who lies, even that one day when you're saying the truth, the judge will not believe you. I recall a time when a judge mentioned in open court that the lawyer who an application was being made on his behalf is not known to be intimate with the truth. And at that particular point, the whole court burst out laughing. And the judge asked what my view was. I was sitting at the bar with the other lawyers. And I told the judge that even a broken clock twice a day says the right time. So this, I would want to believe this is one of those times when I ask you to believe the person. So Justice Antonin Scala, in his book, Making Your Case, it reminds us that judges are not persuaded by theatrics, but by advocates who respect the intelligence and guide judges logically through dispute. Confidence thus begins not in the voice, but in the mind. So how do you think and act like a courtroom lawyer? The first evolution that a young lawyer must undergo is mental, that entails deliberately moving from being a mere participant in the legal space to being a leader and an advocate. Advocacy is not about telling the court everything you know, but rather deciding what the court needs to know to decide in your favor. This decision-making process is what entails good advocacy. Courtroom lawyer ensures three things are consistent. Firstly, that lawyer must understand his or her brief. Secondly, the lawyer must be able to identify and frame the issues arising from the dispute and upon which a determination will be anchored. And then thirdly, the lawyer must work on a strategy that controls the narrative at the very onset. To do all this, the lawyer is required to have a deep understanding of the brief and undertake a critical analysis of the same rather than engage in it as a clerical exercise. As a lawyer, it is imperative that you understand which facts will advance your case, which facts are neutral, and which facts are detrimental to your case, yet which must be addressed. Indeed, that comes out very clearly when it comes to cross-examination. There are many a times when you find a lawyer asking a question which doesn't advance their case, rather kills their case. I recall once upon a time in a cocktail, end-of-year cocktails where we had judges with us, I was then talking to the late Chief Justice of Kenya, Evans Gishero, and he told me something which stuck in my memory to date. He told me a lawyer needs to know when to sit down. A lawyer needs to know what to ask and what not to ask. And he gave me a story, which I am not sure whether it's a true story or whether it was a fable, but it passed the message. He says that an accused person had been charged with violently robbing someone. And the person who was a complainant was the star witness. But from the examination in chief, it was obvious that because of the heat of the moment, he had no opportunity of seeing every event that was taking place leading not only to his robbery, but loss of his ear. So once the accused lawyer had established that doubt, the accused lawyer then asked a stupid question. He asked the accused person, the witness, then why then do you say that my client is the one who bit off your ear? And yet you say you did not see or was unable to see what was happening. The complainant who was on the witness box said, yes, I didn't see him biting my ear, but I saw him spitting it out. So this was the typical case where a lawyer was asking a question which merely sealed his client's fate. And in courtroom litigation, one must be strategic in decision-making, in the advocacy, and more importantly, in client management. Confidence in advocacy is inseparable from a strategy. One of the greatest disservices lawyers render to clients is failure to exercise independent judgment. Always remember, you are not your client's mouthpiece. And at the end of the day, whereas you take instructions from your client, but when it comes to strategy, it's for you to come up with the strategy. Many a times you will find a lawyer has a whole set of questions which the client has passed over to him, or even arguments when it comes to appeals or applications. And the person goes to court and starts reading those questions or those notes. It doesn't take long before the judge recognizes that this person is merely a mouthpiece. And even if those notes are making sense, there's already a bias as against the advocate. So it's important as a young advocate to learn how to take instructions from your client, how to share your strategy with the client, and also let the client know that the strategy you're adopting is aimed at gaining or obtaining a suitable result for him. As a lawyer, you must also choose which battles you want to engage in. You must manage your client's expectation and understand that restraint is sometimes more persuasive than excess. It's important to know when to stand down. Your confidence develops when your decisions reflect foresight and are not impulsive. You must cultivate a professional presence that commands respect and trust. Amy Cuddy, in her book, Presence Bringing Your Boldest Self to Your Biggest Challenges, explains that presence is the ability to be fully grounded and authentic under pressure. In the courtroom, this translates into calm speech, deliberate movement, and attentive hearing. Communication is not merely verbal, it's also behavioral. How one carries themselves communicates more than what one says. For we older people who have walked this journey ahead of you, we owe it to you by way of mentoring your generation. We've got to mentor you and give you leadership opportunities, but at all times, remind you that ethical excellence is key. Confidence will not be achieved through isolation. The mentorship will provide what the law cannot provide. A good mentor will teach you not only how to win, but how to cope with a loss. It is important to understand every stage of your practice, your reputation is built, and the building of reputation is cumulative. But the converse is also true. The destruction of your reputation is not cumulative, but may only take one event to destroy it. Every appearance, every interaction, every concession will either build your reputation or will erode it. It is important to remember that your reputation is your bedrock, it's your portfolio in the legal profession. So, in your journey, you will win cases, you will celebrate. In your victory, take your victory with grace. And in your loss, also take it with grace. Because it is in that loss that you are able to learn where things went wrong, what you could have done better, or better still, what you can advise your client on how in future to address issues. Going back to persuasion, which is the heart of advocacy, it rests on three pillars. It rests on your credibility, it rests on your logical argument, and it also rests on emotional intelligence. Persuasion is not always about winning arguments, but rather aligning your position with your audience's view. In this particular case, the court. To achieve all that, you don't just carry your file and walk into court. You must prepare, you must research, and you must communicate your client's case to the court. So always remember that confidence in advocacy is built deliberately. It is an exercise that takes time, and little by little, you will get there. Scalia, judge of the Supreme Court, once said, the art of persuading judges well stipulated that you would have no confidence in a carpenter whose tools are full and rusty. Lawyers possess only one tool to convey their thoughts. That is their language. They must acquire and hone the finest, most effective version of that tool available. They must love words and they must use them. Exactly. In closing, I'll tell you, as a young and upcoming lawyer, the greatest asset you have is potential. It's an asset which can only be optimally exploited by hard work, dedication, and fully employing your respective abilities. Potential is like a rubber band, in the sense that a rubber band is only useful to the extent that you can stretch it. And so is potential. Potential is only useful to the extent that you can stretch it. And even as we walk this journey, we must rekindle an enthusiasm for the good and the right and the just. And ladies and gentlemen, welcome to the bar, and I look forward to further engagements in this journey, in which the only friends that we have is ourselves. Your clients are not your friends. Always remember that. You are only going to back on the same side for as long as you're delivering favorable results. When things go south, whether it was your fault or their fault, you will be the bogeyman or the bogey woman to be to be uh, to be blamed. So don't go to court shouting at the judge, being rude to the judge or the magistrate because you want to impress your client. Don't be rude to your colleagues. However much the litigation is adversarial, always remember that we are first and foremost advocates, officers of the court, and we owe it to one another to always carry ourselves with decorum. I thank you all.
Thank you so much, Senior Counsel, Tacho Odero. That was ah. Before I even say what that was, I'd like to involve the audience. So hello audience. You are watching, you're a participant. Like you in the next 10 seconds to think about how Senior Counsel has impacted you. You've reflected, how do you compare your advocacy journey with what Senior Counsel has just talked about? And if you can do that, just drop a word on the chat section, how you feel about this presentation. And yeah, I'll give you 5 seconds. 5. And as you do that, first I'd like to say thank you so much, Senior Counsel. You really taught us a lot. You taught me a lot. And from the beginning of your presentation, you told us that even in shyness, that is not a reason for you to not communicate that which you ought to communicate. And this boils down to one thing: communication. Communication is everything. Again, he's also talked about being coherent. And by being coherent, he says that your arguments, they must be based on the law and they must be based on the facts. Additionally, to us young advocates, we are still growing in this profession. We have to be reliable, we have to be people of integrity, and we have to be the person that when the judge listens to, he or she will not have to second guess as to whether we are telling him or her the truth. And again, he said one very important thing. Uh, the court is not persuaded by theatrics. You might be silent, you might be very calm. Talking too loud won't persuade the court. Importantly, he talked about having a strong mental resolution. And by working on your mental strength, it will get you far. Again, you even talked about cross-examination. A lawyer, you need to know when to stop. It's not a must you ask questions. You can sit down and take a moment to breathe. And importantly, he told us that we should learn to take our victory with loss and grace. And yes, with 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 loss and grace. And importantly, he talked about preparation. Preparation is everything. And he talked about us having potential. So this potential, we're going to achieve it by working hard and by putting in the work. Thank you so much, Senior Counsel Chacha Odera, for taking your time. And to the participants, if you have questions that are directed to Senior Counsel, you can take them to the question and answer platform. We'll have an interactive question and answer session at the end of this. Thank you so much. And now I'm going to take this chance to invite the next speaker. Her name is Elsie Michelle Irakoze, and she's going to address the issue of building professional confidence and executive presence as a young lawyer. So, karibu.
Thank you so much, Otto. The speech from the senior counsel Chacha Odera spoke to me too. It was very insightful. And as I was asked to talk about my personal experience on building professional confidence and executive presence as a young lawyer in a fast-paced legal environment. So it touched me a lot because when I first entered the legal profession, I felt so proud, excited, and deeply aware of the responsibility that came with the title lawyer. But at the same time, I felt pressure to perform, pressure to prove myself, and also to show that I deserved to be in every room I entered. But as soon as I entered in my career, I realized that law is not only about knowing the law, it's also about how you carry yourself, how you communicate, and how people perceive your confidence and credibility. So those days, it was really intense for me. And also, sometimes I felt fully prepared technically, but still questioned whether I sounded confident enough. So that's when I started my journey on building real professional confidence and executive presence. In those years, I remember I was admitted to the bar of Bujumbura, Burundi. It was in 2015, but I started practicing in 2016. So in the law firm, I'm still there. I was the youngest person in that period. I was also assumed to be more junior than I actually was. Sometimes spoken over in discussions, and I tend to be careful about how I spoke, so I will not sound too soft or too strong. There was that fear that I don't want to make mistake. I didn't want to be, I wanted to be perfect in everything I was doing, like in drafting conclusions, in meetings, I wanted to be perfect. I started comparing myself to senior lawyers, wondering if I was truly ready for the responsibility I was given. Luckily, that time, the managing partner of the law firm told me something that was really powerful. To feel unsure does not mean that I am not capable. So it touched me deeply because I felt capable. I was sure that I was capable, but those doubts, that emotional overwhelm, it was overwhelming. So I started building my confidence. So now today, what is confidence for me? For me, it's trusting the work I have put into preparation. As the senior counsel said, preparation is very, very important. I started speaking even when I feel slightly uncomfortable. You have to speak. And also being honest when I need to verify information. Before appearing in court, I have to do the preparation. Whenever I don't have any any information I need, I would go to my senior colleagues and ask and verify the information, and even to the client, so that I have the full information before appearing before the court. Also, to stay calm when situations are tense. I know as the senior counsel said, there can be situations that are very tense. It is tense with the client, so you have to stay calm so that your mind it knows very well what the law say, and also to not be rude toward the client and also toward the colleagues. Also, in that part of preparation, you have to. I started reading files beyond summaries. You prepare very well and understand the business or personal impact behind the legal matters. If it is an NGO, what is applied to NGOs? What is applied to corporate businesses? What is applied to this and energy sectors? This and this. And also, I started anticipating questions before court appearances and meetings. Here, I will say that in the law firm I'm in, we were like 90 lawyers. And then I would ask the head of the department I was in, to ask me questions so that I can practice before going to court. And also for meetings, this applied also to meetings. So the preparation reduced my anxiety and made me feel so grounded. After that, one of the biggest growth moments that applied to my career is to learn how to speak with clarity and intention. I started speaking slower so that everyone can understand, can get what I'm speaking about, to finish the sentences, and also reducing apologetic languages. Here, I can give an example. It was in 2017. There was the ELS conference, AGM. It was in Entebbe. And I was given a slot to speak before in the leading law firm meeting. I was new in as a lawyer, and coming from a country where we speak French, I started my presentation by saying, "Oh, sorry, I'm coming from Burundi. We mostly speak French. So if you don't catch very well what I'm saying, please bear with me." And after the presentation, one of the senior who was there in the leading law firm meeting, he came and said, "You don't need to apologize. You own the presentation. You know the subject you are talking about. So whenever you say, sorry, I'm speaking French, you attract all the attention is on you. And there is less credibility on what you are saying. So whenever you have an opportunity to go in front of people to present, don't apologize. Go straight, because I understood every word you spoke about. And the other thing, we don't even know French as you know it. So you are lucky you know the two languages. So I felt comfortable, and I stopped starting sentences with sorry, maybe, and people listened differently. So now I'm very comfortable whenever I am in French speaking or English speaking country. It's easy for me to speak, and also they say they understand. So after that, what executive presence means to me is to stay composed under pressure, to communicate clearly, and showing up professionally and authentically. To showing up, what do I mean here by showing up? Showing up is how we show up, how we are dressed, how we react under pressure, how we speak to our clients, to our colleagues, because as the senior counsel said, your reputation is your portfolio. You have to be well dressed, smart, and how you speak, you communicate clearly. It gives you that, you, as we say in French, tu sors du lot. You are, you are known. You are at this one. He can speak. I know when I ask for this and this to represent me in court, he will show up professionally and authentically. And yeah, so it's about making people feel that you are reliable, prepared, and thoughtful. I will talk about some small changes that changed how I was perceived. I started sitting at the main table instead of the back, speaking at least once in the meetings. And also I was eager to do the court appearings. It means that whenever there was a case in my department, I'm actually in the financial department. I was eager to learn about what is going on, to prepare the file, and to do court appearance. And in my country, are still doing physical appearances. So it's very, very, very challenging because you meet there with senior colleagues, senior lawyers, very senior. So whenever you go there, you have to be prepared. Also, I learned about making eye contact when sharing my opinion, and also to pause instead of rushing to fill the silence. Surviving and thriving in a fast-paced environment is something that is very important, because I learned that I did not have to know everything instantly. I became more comfortable saying I will confirm and revert with a precise answer. And I learned to prioritize by asking what is urgent, what is high risk, what needs the senior review. Clear communication became one of my strongest professional tools. And the other thing is about mentorship. Mentors help me learn a lot. My senior colleagues helped me a lot. They created opportunities for me so that I can learn more. And also I learned by observing how senior lawyers were handling court appearance, were speaking, were handling pressure, and interacted with clients. Sometimes I borrowed confidence from people who believed in me until I built my own. My personal professional mindset right now is that I'd add value to discussions. My perspective matters, and I belong in professional spaces. What I'm telling you is like 9 years of experience. I learned day by day. So it was built on small moments. And my key message to other young lawyers is that confidence is built through action. You don't have to stay in your office alone. No, you have to go to do action. The presence is built through consistency. Respect is built through competence and character. Thank you so much for your attention.
Thank you so much, Elsie, for your presentation. I really appreciate it. I'm sure the participants also appreciate it, because from your presentation, you have talked directly about the realities that young lawyers face. Oh, hello. Sorry about that. I'm back. I'm saying, Elsie, thank you so much. You've been able to talk directly about the realities that we as young lawyers face, especially in this fast-paced legal practice. You've talked about the importance of mentorship, because from that you say that through mentorship you've been able to learn a lot, And again, you have talked about confidence. And by being confident, it means that you have to act. Don't sit on your thoughts. If something comes up, act on it. And with that, I'd like to say thank you. And again, I'd love to invite our participants, the audience. If you have a question which you'd like to direct to her, throw it in the question and answer box. And now, moving on to the next speaker. His name is Alex Ntale. And Alex Ntale will be talking to us about the mind of the advocate. Alex, if you're here, are you here?
Yes, I am. I can hear you.
Okay, so Alex he's an associate at LEN Uganda and practicing under MMAKS Advocates, which is one of the leading law firms in Uganda. Alex works in the employment and litigation teams, and he handles litigation matters that arise out of commercial disputes. Alex is actively involved in the employment practice, and he routinely advises on an array of employment issues, including but not limited to restructurings, review of employee handbooks, termination and dismissal of the employees. He also handles several employment-related matters before the industrial court and the Court of Appeal in Uganda. He has participated in several employment law webinars, podcasts, and conferences that have been organized by the Employment and Law Alliance of the Uganda Law Society. Alex was able to graduate with a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal practice from the Law Development Center in Uganda. So Alex, the floor is yours. I look forward to your insights.
Thank you for the warm welcome, Pato. I will speak about a couple of issues, and I think one of those is being nervous or nervousness and the expectation to perform under pressure. I think it was quite interesting how you set up the presentation by bringing senior counsel to speak to us. And for the young lawyers, I think that in itself coming to speak after senior counsel would ideally create nervousness. But I see it as a privilege to speak after senior counsel and the wise words of wisdom that he has shared with us. I will speak about what causes this nervousness in court and why sometimes you believe that you cannot perform well as a young lawyer. And I'm going to be sharing a lot of my experiences, and I believe I will help one or two young lawyers. I think one of the things I can look at is a fear to fail. As young lawyers, you come out of law school watching a lot of maybe movies and watching a lot of series about performance, about cases being finished in one day, and then you come into a practice where you're expected to perform without failure. So that in itself can create nerves, and you're not able to address the court well. You're not able to address your colleagues well, and because of that, you're not able to perform at peak performance. The other thing I can share is that sometimes we have high expectations of ourselves, which is a good thing. But because of that, you appear before certain courts. We have a common practice in Uganda here, where if you're unable to address the judges by their right name or by the desired calling, they will ask you whether you have a practicing certificate. So once you are at the bar and you hear a judge asking, "Do you have a PC?" You just know that lawyer has created a scenario, a situation in court that is being perceived as if he's nervous, as if he's unqualified. So as young lawyers, and I think that's one of the things that you look at to avoid if you want to avoid having nerves and ensure you perform well. The other thing which I see, and I'll share my 2 cents on what you can do to avoid these nerves, but I wanted to first identify a few things. Senior counsel has told us that your confidence is not in the voice, your confidence is in the mind. So when you come before the court, always know that for you to be firm, to be persuasive, you must be able to be confident in your mind before you utter any word in court. I practice mostly in a court which has a panel of 4 officers led by a judge and other panelists in the Industrial Court of Uganda. And most of the times, lawyers who are not used to this court don't know how to address the court, even from the word go. And I think it kicks in that you have to know your forum, the forum that you're going to address, and speak eloquently from the word go. And that, of course, is a mental thing that you always think about. Another thing which I see that causes these nerves in the young lawyers, sometimes you come and you want to perform and you hit certain targets. You have so much pressure to maybe hit your performance targets, hit your milestones set by the law firm, by your own chambers, by your own self. And sometimes that causes you to have nerves and have performance pressure. But I think what young lawyers should know, and I don't believe I'm yet a very old lawyer, which is debatable, is that you're not expected to be perfect for every court appearance that you attend. Sometimes along the way, something may happen. They may raise a preliminary objection which you did not anticipate. You may find that you've forgotten certain court papers that you did not carry. There's a lot of things that can happen. So you always have to be adaptable to the situation you're dealing with, and always be willing to either ask for an adjournment or ask for more time, ask for a standover of the matter before you proceed with your session. So it's not a do or die that you must always proceed with the matter unless a judicial officer persists. Another thing which I see that causes nerves in young lawyers, and I think it's something that we've all experienced if you have been going to litigation. Sometimes you handle high stakes briefs. It could be, for example, in Uganda, currently you're dealing with an election petition of the challenging the presidential was allegedly withdrawn. You could be a counsel in that matter, and you believe this is a high stakes litigation, and there's no way you are going to underperform. So that in itself can cause nerves and performance pressure. And sometimes the value of the subject matter that you're dealing with, the case may not necessarily be high profile, but you're dealing with $5 million, $10 million, $100 million suits, and you believe that if you fail, probably you won't maintain the client. Another thing, probably what I can share about what may cause nerves is you being unfamiliar with a court that you attend, which I probably mentioned earlier, that you always have to be cautious before you appear before new tribunals, before new courts, and make sure that you prepare and know how to address a court, how the specific courts deal with litigants, and how they deal with the Okay, the network dropped. Sorry about that. Can I go ahead, moderator?
Yes, we can, Alex. It's okay. All is good. Let's continue. So far, so good.
Thank you for that. And I think these are expected. And these are things that cause nerves when you're appearing before court. I think I'll give another example touched on by Elsie. I've spoken at a number of webinars and podcasts and conferences and trainings. And I think I remember vividly my first training. I was addressing an audience for Africa and Middle East. And I spoke so fast. I had 30 minutes to speak. I've been given 30 minutes to speak as my allocated time. And I think I finished my presentation within 10 minutes. I spoke so fast, and I don't think the audience really captured what I was saying. But then as time went on, I discovered that sometimes when you're speaking, people people are interested to hear what you're saying, either before a court or before a forum like this. And sometimes you know much more when you're speaking, so you don't have to fear to say it. Sometimes when you speak, you're a bit nervous, you're anxious, and you think the people are listening to you, are judging you on the other side. But sometimes when the judges, we address the magistrates, they want to learn. And it's common practice in our jurisdiction where the judges ask you, the counsel, they inform you we're not very familiar with this specific area, address us. And you're literally running a lecture in court. Of course, may not be appreciated by the opposing counsel, but it's common. So with that experience over the years, I learned that when you speak with calm, with confidence, you realize that you will be received well, and the information that you provide will be received well by the judicial officer. The other thing I've learned through the practice and observing from the senior colleagues who have gone before us is possessing high level of knowledge. I think this one may slightly differ from being calm. You build your knowledge store. You're able to speak confidently. In my area, where I practice mostly in the employment space, any day you call me on any issue that you call me, I'll be able to address the specific issue. And because of that, you are banking on yourself that any day, before a judicial officer, you will speak comfortably, you will speak without any nerves, and you perform. And even over time, the judges will start respecting you. When you come before them, they always believe that what you're saying is probably the truth, and of course gives you an edge in the matters that you handle. And I think related to that, you must get the requisite competence. And I think this is a very common practice in our practice. It's a common issue in our practice. You should always be willing to hand over matters where you believe you lack the requisite qualification, the requisite ability to adequately represent a client. Of course, it comes with a lot of, or probably I may even fail to get the word to use, but you must be able to we call it cross-selling in our practice, that you sell to another team, areas where you feel they will do a better job. As a young lawyer, you may think because you have studied each and everything in law school and the law development center that you may attend, that you can practice each and every aspect of the law. And before you know it, you're there, another lawyer raises a very straightforward objection, and your case falls. So as lawyers, you always be willing to share cases, to cross-sell in areas where you believe another lawyer has the necessary competence to handle matter. And I think one other thing I can share from my experience in practice is that always be willing to adapt on short notice, especially when you're litigating. We have different judicial officers. Some of them take on the challenge of asking lawyers questions midway the trial. You may face objections from the other side, and some just that interruption and disruption can throw you off. You have come with your questions prepared, you have come with your cases prepared, and because the judge has taken you in a different route, you're all of a sudden off and you're nervous and you cannot perform. You should normalize that you're going to have imperfection in your presentation, even where you fall short in a specific matter. Know that in another case, you're going to do better, you're going to represent the client better, and that builds confidence over time and will kill the nerves as you continue going through the court process. Maybe one more point I can mention is that you should detach yourself from this client's case. Senior counsel has told us that our friends are actually the lawyers and not the clients. So know that the case is not yours. The case is a client's case, and you do your utmost best. You follow the advocacy regulations and rules on conduct. And once you deliver, if you are pleased to win that case, you thank the Lord for that, and you prepare for the next one. If the case is lost, don't carry on that, and it will affect your performance in in other matters that you do. For now, I will just stop there and allow other panelists to share their presentations. Thank you.
Thank you so much for that, Alex and Saleh. Don't go anywhere. Don't go anywhere. Remain there kindly if you can, because I'd like to call the first three speakers who are right before us, Mr. Chacha Odera, Senior Counsel, and also Elsie Michelle. Are you still with us?
Yes, I'm
Yes,
here with you.
I am.
Okay, yes. First, with Elsie, first, I'd like to apologize. When I called you, my internet just dropped all of a sudden, and your intro was a bit rushed. So for that, I am pretty sorry. And let me give you a
Okay.
let me give you an introduction first before I can join the two of you together. So Elsie Michelle Irakoze, she's a junior partner and she's a chief operating officer at Rubea and Company Advocates. This is a leading law firm in Burundi. The firm is a member of DLA Piper Africa, a Swiss variant comprising of independent law firms across Africa that collaborate with DLA Piper. She's an advocate of the Burundi Bar Association and provides advice on a broad range of legal matters in Burundi, including banking and insurance law. She has over 9 years of experience in her business law, and she has demonstrated expertise in navigating complex regulatory frameworks, and she's quite positioned to address the challenges of talent retention and integration in the modern legal profession. So this is where now you come you this is where now you come in, and from the three speakers that we've had, we've been able to see that each of them has talked about confidence and has talked about mentality. And as we go on with the discussion, I'd like them to have a brief rejoinder again on what they believe confidence and mentality is. So at this point, I'd like to invite the three of them together for a joint discussion on the mental side of confidence. Tell us something that we young advocates can stick with, so that we can so that we can understand how to channel our confidence, and how to make sure that once we've channeled our confidence, we have the mental capability of maintaining it. So welcome.
Otto,
Yes.
you're inviting all three of us?
Just briefly for less than 3 minutes.
Well, allow me just to say one thing, one sentence, and it's something I'm throwing out there for consideration by not just the panelists, but the audience. There is a distinct difference between confidence and arrogance. And I dare say that confidence is somebody who knows that he knows and delivers what he knows. Arrogance is that person who thinks he knows but doesn't know and delivers what he doesn't know. So it's important. And that speaks to emotional intelligence. Thin line between confidence and arrogance. Always bear that in mind.
Okay, thank you. Alex or Elsie?
Okay. Otto, I was about to talk about true confidence that stems from ongoing learning and demonstrated skill. You earn respect from clients and colleagues. Yes, it's an ongoing learning and demonstrated skill. That's what I think is true confidence for a young lawyer. Thank you.
Okay, thank you for that. Alex, you're up next.
Okay, so for me, what I can say about this confidence, emotional intelligence, I think the first thing I would advise the young lawyers is active listening. And I think sometimes it can be frustrating when you appear in court. And most of the time, as opposing counsel, you are you are listening always to respond. As your colleague is speaking, you are listening to respond as opposed to listening to understand what the other colleague is saying. And because of that, you may miss out on specific aspects of the case that may be helpful. The other thing which I can say is self-awareness, and I think it has come up in this presentation. And sometimes with the lawyers, when you speak and you feel like you're confident, you're winning the room, you're playing to the gallery, and you're missing the entire point that you're losing your client's case. You're banging the table, you're shouting, you're being abusive. You should always be self-aware and confine yourself within the advocate's performance conduct. And when you do so, you'll be able to deliver a result for your client. And the last thing I can mention probably is empathy. As lawyers, sometimes when you cross-examine a person and they cry and you feel like, oh, wow, I've done a good job of cross-examining someone and they have probably collapsed. And some of those probably the young lawyers have to pick up and know that when you do that, you're not actually doing a good job, because you should have empathy. Sometimes when you cross-examine someone and you feel like they're in a place where you have made the point, you don't have to hammer it to make sure the person cries on the stand and you satisfy yourself and your client. And I think that's something that we should have empathy. You know, when they teach us in law school that you should take out all your emotions, practice the law, I think it's something that you have to grow and know you can take a moment for the witness to recover themselves and you continue with your cross-examination. I think that can go to speak to emotional intelligence for lawyers.
Okay. Thank you so much all for your inputs, and let's get the train moving. So I'm going to invite the next speaker, Jebra Kambole. Are you here with me?
Yes, I can hear you.
Welcome, Jebra. So the Jebra Kambole, he's an advocate of the High Court in Tanzania, and he is the founder of Law Guards Advocates in Dar es Salaam. Jebra is a former member of the governing council of the Tanganyika Law Society. He is a seasoned criminal, constitutional, and human rights lawyer with extensive experience in strategic litigation. And he has represented his clients in the High Court of Tanzania and the Court of Appeal, and also the East Africa Court of Justice. So today here we have Jebra Kambole with us, and he is going to focus on commanding the room, voice, body language, and advocacy resilience. So we give a warm round of applause to Jebra Kambole. Welcome.
Thank you so much. I would like to start by saying that thank you, East African Law Society, but also thank you for Senior Counsel Odelo, Erakoze, and Ntale for that background. I appreciate the background, and I will try my best not to repeat the points which has been made by my colleagues. On commanding the room or on speak in cases, as a young lawyer, what I can say is I've been in the practice for more than 12 years. So I was admitted in 2014. So I will try to share the practical aspect of the litigation. On commanding the room, the colleagues have been explaining about the understanding the law, the fact, understand the case, you do your research and so on. But in litigation, we know the importance of voice, the importance of speaking. And what I can say to young lawyers is when you appear before a judge or a magistrate, you need to understand your case and you need to speak loudly. When I say loudly, I don't mean shouting. So you need to be loud and clear. You need to be loud and clear, but also you need to speak slowly in the pace. How do you understand the pace? You have to consider according to the nature of the magistrate or the judge. Some judges are fast in writing, others are very slow. In other courts, the judges are also typing the proceedings, others are recordings. So you have to read the pace of the magistrate or the judge, so to make sure that your point are being captured very clear. And among of the things which I usually consider in myself that whenever I'm speaking and I see that the judge or the magistrate does not write it, then I think that no, maybe I'm not speaking a clear point. So that you have to be very careful. Listen to the judge, listen to the judge, see how he or she is speed or slow in writing. So speak in a pace on which you can be very clear on making your points. That's how it makes you a better lawyer. But also, especially in open court, don't try to speak while you are sitting. Stand up and speak loudly. That's the way on how you can communicate easily with the judge. The second issue on the voice, it's also helping your client to speak loudly. So sometimes you may be in a court, but you have prepared your client to speak and your client speaks slowly, just because in the witness box, you also stay near witness box. And this client, knowing that he or she speak to you. So in my practice, usually, when I conduct the examination in chiefs, especially when I lead my client, or I'm conducting cross-examination, I usually try to stay far away from the client, so that the client, when he or she speak to you, she speak loudly so that you can hear from the far. And that situation, you help even the judge to hear the client on how he speak. So that's how you can handle the case properly. But also, the other thing you have to consider is you need to speak. When you are speaking, you need to speak in a manner that you are in contact with the proceedings. You are following up the proceedings. So body language is very important. Eye contact is very important. So the way you are looking to the judge, the way you are looking to your client, the way you are doing cross-examination matters a lot. So you need to have the eye contact. So if you ask the question to your client, look to them how they are responding. When you are responding to the judge, look to the judge. But also, occupy the space. Occupy the space on the sense that when you conduct cross-examination or make submissions, you need to have a space in submitting your case. So don't stay in a chair or in such a way that you look like you don't have any confidence. So stand up, make a movement. If you're in open court, speak loudly in the sense that even the judge or the other party know that these guys know the case. But also, if you are maybe in the Court of Appeal, example in Tanzania, most of the time we appear in the Court of Appeal in such a way the judges may ask you questions. So facial expression is so important that you need to show that you understand the question. You appreciate the question. So it's easy for you to respond in the question asked. But also the last point I want to make it very clear is advocacy resilient. When you are in court, you conduct your case. Try your best that you may be practicing in your chamber or somewhere you prepare your answers. You need to be flexible to make sure that you understand the questions. So you may prepare the answers, but you may be asked the other questions. So be very flexible to understand the questions. But also respond exactly on what the court asked. Respond exactly on what the court asked. So be in that position that you understand the question. So don't go to court with your own answers, because sometimes you may be surprised by other questions which you were not thinking about, that they may come or they may not come. So prepare yourself, but also be flexible and be sharp to respond by referring to our pleadings and so on. So that will assist you to win the case. But also in some situation on which you are in a corner in such a way you find that it's very difficult to respond. Maybe you don't have enough research. Maybe you you are not prepared with that question, don't force yourself to that situation. Be sharp. If it's possible, ask for adjournment so that you can do more research, so that when you respond properly. And if you see that there is no way, look to other opportunities, like asking for amendment, asking for refiling of the case, but make sure that you are flexible, you understand the questions, and that way it will assist you to be a better lawyer. So as a young lawyers, you should not be afraid. Occupy the room. You should not be afraid that you are facing maybe the senior counsel, the opposite side. Do your research and be comfortable. Understand the question. Respond to questions clearly, loudly, clear, but also sometimes slowly, if you want your point to be very clear by the judge. So let me end there and left for other colleagues to continue. Thank you so much.
Thank you so much, Jabra Kambole, for your very insightful presentation. So from what we've gotten from Jabra Kambole, he has given us a practical and highly relevant perspective on understanding the questions that have been asked by the court and also by reading the room. So the skills that we can get from today's discussions, they are crucial for every young lawyer, including myself. And these skills are essential to enable you and I as an advocate to command presence in court or in any other professional setting. So thank you so much. And now I am going now to take this chance to invite the next speaker. The next speaker goes by the name Timothy Lugayezi. Timothy Lugayezi, are you here with us?
Yes, I am here.
Welcome. So Timothy Lugayezi is a senior associate with the litigation team. He's mainly involved in commercial litigation. Timothy Lugayezi holds an LLB degree from Makerere University and a postgraduate diploma in legal practice from the Law Development Center. Timothy competed in the 2018 Weber Wenzel Litigation Association Foundation program held in Johannesburg and has featured in the prestigious Chambers and Partners Litigation Guide 201 as a co-author of the law and practice in Uganda. Timothy is a Christian. He's interested in public speaking and sports, especially football, and he has been fortunate to participate in several groundbreaking commercial litigation and is quickly gaining recognition in the market. So welcome, Timothy. His theme will be what law did not teach us, and this will be the practical lessons from the front lines of legal practice. Welcome.
Thank you very much. I appreciate the glowing introduction. I hope I can be heard clearly.
Yes, you can.
Okay, perfect. I'm going to speak about a few things that I was asked to talk about, a few things that they do not teach you at law school. So what I'm going to focus on is mostly my practical experience while I've been practicing law. I've been practicing law for 13 years. Interestingly, I started my practice with the law firm that I work for 13 years ago, and we're still counting. So I'm glad to share my experience with the younger lawyers. I also consider myself young, and I think, as senior counsel said, it's a continuous learning experience. I cannot say that I know everything I need to know about the practice, but for what I know, I am happy to share. So firstly, I'm going to talk about the courtroom because my experience is in the courtroom. I do litigation on a daily basis. So every week I probably go to court maybe 4 to 5 times. On a very lazy week, I'll probably go to court twice, but I am in court every single week of my working life, except during court vacation. So I have learned a few things over the years and I'm going to share with you what I know. The first thing I would tell a young lawyer who is practicing litigation is you need to know your audience, you need to know your judge. And that's probably something you've had before, but maybe what I can add to that is to speak about some of the experiences I've had. Knowing your judge is something you hear, but no one tells you how to know your judge. Knowing your judge is made simple by you doing the simple thing, which is reaching out to the court clerk of the judge. These guys who sit next to the judge throughout every court session, who follow the judge even when the judge is transferred or goes on an upcountry court session, get to know these judges a bit more intimately than we do. So knowing your judge means understand the temperament of your judge, know what the judge's do's and don'ts are. There are some judges who are very strict, for example, on dress code. There's a very well-known Ugandan lady justice who will not hesitate to chase you out of court for not combing your hair. Something as simple as that. But again, you have to appreciate that it's not even about her being strict, but these are simple grooming lessons. If you skipped your nursery lessons on good grooming, then you have to be told by the judge to get out until you have your hair combed so you can come back in. There are other basic things like knowing whether the judge will sit in the open court or in his chambers. You can know that by a simple phone call to the court clerk, and the court clerk will just let you know, today we are in chambers, and for the lawyers, at least the ones who practice in Uganda, what that means is that you do not have to come robed in your full courtroom regalia. You can come in a suit and tie, just like I'm dressed now, if you're going to chambers. If you're sitting in open court, then you must come with your flaps and your gown and be ready to address the judge, whether it's a mention or a hearing. You must be fully robed while you're in open court. There are some judges who don't mind you being simply dressed in a suit, even while in open court. There are others who will not give you audience if you are not well dressed for court. So it's important to simply pick up the phone and call the court clerk to find out where you will be sitting. Another thing maybe I can share as an experience is there was on this one occasion I managed to impress a registrar simply by smelling nice, which is something you will not be taught at law school. No one tells you to include perfume on your invoice items when you're invoicing the client. Bill the client for that perfume because it might get you an ex parte order like the one I managed to get because the registrar was very happy with how I made her chambers smell on this one occasion. But all that comes down to knowing your audience and very simple things like good grooming. Another thing I want to talk about is your credibility. I believe credibility is the real currency that you carry as a lawyer. Senior counsel there touched on it, and he talked about being believable. He also said that we do not speak for our clients. I think I won't disagree with that because I agree in part, but I would like to just add to that and maybe qualify it a little by saying that we, in fact, do speak for our clients. However, our clients do not tell us how to speak for them. Our clients instruct us, and sometimes your client will instruct you on something that says unlawful. That doesn't mean you go in front of the court and speak about unlawful things. You decide how to tell your client's story. So we are the client's mouthpiece, and therefore, each time you speak to the court, you must be believable. So if you have built a reputation of lie telling or telling lies, then on the one occasion that you seek an adjournment because your wife is in hospital having your first child, or because you lost a colleague yesterday and you need to go for burial, all of a sudden when these things are true and you're actually seeking an adjournment on credible basis, simply because on the last few occasions you are telling lies that were discovered, you will not be able to have the credibility to be believed by the judge. So things as simple as that are what will taint your very young career. If you are not reliable, however brilliant you are, you will not be able to carry the respect of your colleagues and of the judge who is your audience. I'll also touch on respect, being respectful. You have to be respectful to both the judge and to opposite counsel. Many times we forget the importance of staying in favor of even opposite counsel, because I've spoken about the judge. Opposite counsel is your opponent. They are not a lifelong nemesis. So if for you in every single case you get, as soon as you get an instruction, you're thinking to yourself, this is an opportunity to make a new enemy. I'm on enemy number 25 now. I want to make 26 for my next matter tomorrow. That can't be your go-to as a young lawyer. I've found in our practice that having respect and collegiality takes you very far, because you do not know when you will be the one who is in need of a favor from the other side. I'll share a recent experience. There was a case that I handled recently where we filed a summary suit against a debtor. The debtor's lawyer filed an application to for leave to appear and defend. In a summary suit, you file an application for leave to appear and defend. That's the response to the suit. He filed that application out of time. It was late. Now, when he filed it out of time, he filed another application to validate his late filing, or to extend the time for his late filing. When we went to court, he didn't ask me about my view on his application for extension of time. But I went to him and I told him, you have your application for extension of time, and you also have your other application in response to the summary suit. I told him, I want to oppose your application for extension of time. Let's just go straight to the summary suit. And when we appeared before the judge, he let the judge know that I conceded to his application, and I confirmed it, and the matter went on. So the judge, we had an interaction with the judge about the merits of the case and whether the matter can be settled. And that opposite counsel was being a bit difficult in his stance on settlement. And the judge lambasted him and told him, you are actually wasting our time, yet opposite counsel has been gracious to you by allowing you to proceed without having to argue your application for extension of time. That made me feel like the judge was taking notice of the fact that I had been gracious to opposite counsel. And I was glad that she took note of that, because I would like to create the reputation of not being unnecessarily combative on every point. And the reason why I conceded to that application is because I knew in my heart of hearts that the judge would have granted it, but it made me look better if I didn't have to make the judge make that decision. So sometimes, actually, my grace was more strategic than heartfelt. I did it to gain an advantage, which I believe I did later on in the case. Long story short, or fast forward in this same story, this person was granted leave to defend that case, and he filed a written statement of defense, which had a counterclaim. Now, our new laws say that when you file that kind of response on ECMIS, our ECMIS is our online filing system. You don't have to serve the other side, because the other side can see it on the ECMIS system. I have an issue with that law, but that's a debate for another day. However, I did not notice that he had filed
Oh, hello, Timothy. Are you with us?
Can you hear me?
Yes, we can hear you.
Okay. Yeah, sorry, the internet was a bit unstable, but I'm about to wrap up, so let me get to the point of that story. So fast forward, this person files a counterclaim. In this case, he was given leave to defend the case, and he filed the counterclaim. I didn't notice that the counterclaim had been filed until time had run out for me to file a defense to the counterclaim. So I picked up the phone when I noticed that I was out of time, and the first person I called was the opposite lawyer, and I reminded him, if he remembers, that day that I showed him grace when he filed out of time, and I asked him to extend the same courtesy to me, which he did. And the only reason he did that is because he remembered that I had extended him the same courtesy before. So in our practice, the lesson there is, if you're respectful and if you're courteous, then you do not know when you will need a bit of grace extended to you. So these colleagues of ours that you choose a fight with today will be the ally you need tomorrow. Yeah, so I think I will stop there for now. I have a lot more to say and very many examples to give, but I appreciate the opportunity to be given an opportunity to speak to all of you. It's not every day that you get to speak to the whole East Africa, but we thank you, Mr. Otto and Gabriel, for the opportunity, and I'm here for it. Thank you.
Thank you so much, Timothy, for your very insightful presentation. And one of the take homes that we can take from this presentation is the fact that the opposing counsel is not your enemy. And even when you are dealing with the opposing counsel, you have to be respectful, because the profession that we are in, it's a lifelong profession, and you don't want to be making enemies unnecessarily, because they are our colleagues, and in one way or another, you yourself, you might be in a fix, and he or she might come through for you. So thank you so much for that. And now we invite the last speaker for today, and this is Crispus Mutabuza. Are you with us, Crispus?
Yes, Mr. Trump here.
Okay. So before I introduce Crispus, now this is to the audience. After this session, you're going to have an interactive question and answer session. So if you have any question that you'd like to direct to any of our speakers, kindly post it on the question and answer platform. And also, if you have any comments, any recommendation on how this webinar is being run, please feel free. Now back to you, Crispus. So let me introduce him. So Crispus, he's a distinguished multi-jurisdictional lawyer with dual practice credentials in both Uganda and Kenya, providing him with a rare and valuable perspective of the legal and business landscapes of two of East Africa's vibrant economies. His expertise spans corporate commercial law, finance, and projects, allowing him to offer strategic and comprehensive legal advice that are tailored to the unique regulatory and business environments of the region. He has over 10 years of experience, and Crispus has built a solid reputation for advising both local and regional businesses, as well as individual clients on a wide range of legal matters. Again, Crispus, throughout his legal career, he has held key leadership roles, including partner in a cross-border practice, business development manager, people and culture manager, where he successfully managed and grew teams while fostering a culture of excellence. He is dedicated to helping his clients, and he's also he's an advisor to a wide range of businesses and institutions across East Africa. So the floor is yours, Crispus. Thank you for gracing us. Over to you.
Thank you very much. Thank you very much, moderator. Good evening, good afternoon, colleagues. My name is Crispus Pavuza. I'm an associate partner at KTA. This is my 10th year of legal practice, so I hope to share one or two things to you about professional identity, ethics, and an authentic voice. Moderator will excuse the fact that I'm the only one presented with a PowerPoint. The reason is because I tend to speak for an hour about some of these topics. And so this is really just 8 slides of content to tell me when to stop. Otherwise, I might go for 1.5 hours on some of these topics. So yes, just to quickly go through the learning objectives for this session, I think they're quite clear there. It's to just get an understanding of professional identity. I believe that's the crux of what I'll actually be presenting on. The rest of the other topics I've had a bit of input from the rest of the panelists. It's a very good panel that you put up, moderator, and so I think those will just be able to breeze over them without necessarily taking a lot of your time. So maybe probably more important than any of the slides that you'll see, I think it's this next one, which is on why this matters. And for me, the aim is just to bring context to this discussion, because oftentimes at least the presentation I'm going to give from here tends to be classed as, boring, inspiring, a bit abstract, okay, I should say. And so I thought to just go through this to show why this really matters and directly impacts into our local individual context. So the first one there is privilege, flagship, mentorship, pressure. So as you heard in the introduction, I did practice in Nairobi as well, Uganda. Nairobi it's called pupillage, Uganda it's flagship. So really the aim here is to just understand that stage that the advocate normally gets into, either when they're just about to qualify, or when they just set out to practice in their first year, most likely. And the point here is that oftentimes your professional identity gets to be defined by whomever you practice under, that is your supervisor, your mentor, your pupil master, depending on your context. And so it's important to be able to understand that it is not necessarily what your pupil master, your supervisor, is the direction they're taking you that should eventually define your career. And more so, the reason as to why it's important that people take stock of the choice of pupillage, of flagship, before they get into the legal profession, because a lot of that tends to define how you view the legal career that you're in from there onwards. And then the other is, of course, related to the other. If you find your supervisor or your mentor in the hustle and bustle of life, maybe you join a law firm in which it is win at all costs, right? And so you tend to define your career through that lens. So before you know it, 10, 15 years down the road, and all you are is you're a hired gun for clients, right? And because your supervisor let you understand that it is only by this method and this cutthroat modus operandi of delivering results that will butter your bread, and add in your sugar or sugar in your tea. And so because of that, there is a need to understand why your professional identity is crucial to who you are as an advocate and how your career spans out. Okay. And then, of course, again, related, if you hired guns to clients, what does that mean for the public? Because the legal profession is a currency that it is built heavily on trust. I always tell people that if you cross the border, the currency that you have might not quite have the same reputation as the one that you held in the previous country that you're from. And if lawyers have this reputation of being hired guns, I think there's the legal profession, of course, has popular negative imaging that people contend with the profession. I'm sure everyone has heard about lawyers being liars, lawyers being thieves. There's actually an interesting one I came across in my second or third year of practice. A gentleman was giving a career talk, and he started off with a statement of, it was a trick question as to why sharks do not attack lawyers. And the answer was professional courtesy, right? So you're dealing with that, right? And you need to, the question is, where are you in all that? And that's why I'm trying to say that all these things matter, because if your identity as an advocate, as a lawyer, as a young lawyer, is not thought out and is not born of the conviction that you need to define how your career will be, then it leaves you at the whims of wherever you land. Like as I said, maybe your mentor, your supervisor, your clerkship uh, uh, supervisor is of a certain direction, then you're left to their inclinations as you try to forge your way throughout your career. And then maybe lastly, there is on social and political expectations. This one, of course, is so that every advocate practices law in a context and jurisdiction that is peculiar to their context. I think that one is very clear for all to understand, because I saw Senior Counsel Darren was giving this presentation. There was a portrait of Nelson Mandela in his background. Of course, it's not commonly known, but he did start out as a lawyer. And for him, at his time, in his context, you can see how the predicament and circumstances he was in defined who he was as a lawyer. And many lawyers in the civil rights movement tend to have those circumstances again defined for them, what that is for their career. And so everybody has got to look into their local context and understand that your identity as a lawyer and your professional identity in this regard can be, is really something that you can forge out of your own personal circumstances and make it true to yourself that you believe in it to be able to make your career very authentic. Okay. My name was not moving. So the next question there really is, who are you as a lawyer? And as I said there clearly, is that every legal practitioner gets to define this for themselves. And why that's the case is because, like as I've said, the circumstances are very peculiar and unique for each person. But crucially, everybody is able to look into themselves, evaluate and internalize their personality, their traits, their circumstances, their passions, and then define for themselves who they are as a lawyer. Okay?
Yeah.
Some feedback.
Thank you, you did well.
Timothy Lugayezi, could you kindly mute? Kindly.
So I think I can proceed. So really here, what happens is that the standard that we know in terms of our professional identity as a lawyer tends to derive from the code of conduct. And I know we are all from different jurisdictions, but I know for a fact that each jurisdiction has got a professional code of conduct. Okay, short of listing them all here. But I know the Society of Kenya has, the Uganda Society has, the Rwanda has, and so people tend to limit themselves to the decorum associated around those codes of conduct or regulations governing the profession, and yet there is more to that than just what the legislature has prescribed for us. And that's why in the rest of my presentation, I'm going to get into the open heart surgery of the values, of the tenets, of the traits that inform professional identity as a lawyer, because as you know, the legal profession has been it's one of the oldest professions in the world, right? We know that regardless of the change in culture and technology, the profession has generally maintained values that inform it. I think someone earlier, I think it was Timothy, who mentioned that there's a certain judge who prefers a certain level of grooming. People appearing before her, and that's what I'm talking about now. That speaks into the decorum of an advocate. But generally, the legal profession, for its age, we know, for instance, the fact that all law is given by a lawgiver, that the law is completely stated in clear terms, it's binding on the subjects who are the recipients of that law, and then maybe there are sanctions and penalties for breach of that law. Now, for lawyers, are components in the enforcement process of that, right? And in that space, a young lawyer is able to calculate for themselves what their professional identity is. Okay. And then let me just get you through what professional identity. There's something called professional identity formation. I think for the rest of the slide, I will be calling it PIF. This is quite simply the process through which young lawyers, ideally law students, because we should be, or at this stage, someone should be down the line getting that identity crystallized. But lawyers develop a sense of professional self and adopt the values and attitudes that are integral to the legal profession, right? So we do know that this profession, that although it has evolved over time, and although we can attribute it to being one of the oldest in the land, we do know there are certain values that have never left it, and so ways that young lawyers face in all that. Okay, so I add that it's essential, therefore, enabling young practitioners to navigate moral conundrums and understand the nuances of professional conduct and develop the resilience, ethical reasoning necessary to confront challenging situations. So the reason of all that is just to for the young advocate understand that this profession, the legal profession as we are defining it here, I've seen a lot of emphasis on discussions on competence, on confidence, on how you go about navigating various situations that are not necessarily taught in rural school. Okay. The question here, though, is that is there something beyond all that that informs A, your decision to practice as a lawyer, and B, who you are as a lawyer, such that when it comes to presenting arguments before court, they are born of a conviction that means that you do not necessarily need to be prepped up or revved up, or put in a situation whereby you need to be convinced to make that argument before a court of law, before a tribunal. Why? Because it is innate, it is born of conviction. And earlier I think there was a short session on confidence and what the earlier panelists view on it. My submission to you is that confidence is heavily born of conviction. And that's why we are really going into the root canal of values and integrity and things like that. Okay, so just to carry it forward is that in PIF, which is professional identity formation, there, still who you are as a lawyer, any student or young practitioner can cultivate, grow, and internalize their own professional identity, right? So that is the good news. And that's no matter how challenging or whatever circumstances you're in, an authentic path rooted in your professional identity is the key to being the best lawyer you can be. And the components here, which I also noticed that have been mentioned some of the earlier discussions, is something like self-awareness. Okay, and what that really means is that it's necessarily personal. A person needs to really have to know themselves and map out what their values are as a person. Okay, and it is at the heart of it. It's really a challenge for somebody to engage in the fundamentals of who they are, what they want in the world, what you want the world to be, then what is your place and responsibility? Yeah? What is your place in creating that idea that you've set out? And many of these are what inform some of the civil rights movements I've talked about, those who champion the law in their spaces, trying to either reform legislation, to reform society. Many of these causes are born out of this deep conviction, okay? And so it's necessarily born out of self-reflection. Maybe just to bring this home is that individual alignment of these values. Maybe just to I think there's again some feedback, but I'll proceed nonetheless. But a person aligning these personal values to themselves and to their profession at large, really that becomes the source of the difference between the person who gets up in the morning and is excited to go to work, and then the other who gets up and reluctantly shows up at the office but would rather be elsewhere. Okay, they're there because they have to pay the bill, they have to pay the rent, and that kind of thing. And that's why it's important for each person to have that self-examination, understand who they are, align their work to their personal values, and therefore create a conviction in how they go about their day-to-day execution of tasks. And why that is important is because if you get that alignment right and proper, you're able to, in your day-to-day work, attach each and every decision you make to a personal value, to a trait, and nothing to performative motions and actions, or legalism, and simply being forced to do certain things against your innate personality. That, in essence, enables you to present an argument before a tribunal, before a court of law, which is one, very easy to back up. Two, you are able to confidently put it across because, like as I said, it's born of conviction. Okay, this is how some professionals find opposition counsel whom they just can't crack regardless of the weakness of their arguments. Okay, and so the idea here is that when you get this identity rooted in your conviction of your personality, you're able to front up arguments and even advocacy as a lawyer to a level that is not quite much to the other person who is simply doing it out of script reading. Okay, so the tragedy here is that oftentimes students in law school have gone about forging for themselves this professional identity without the right mentorship, without the guidance that seniors pass on, because even professors in law school, why? Because topics such as jurisprudence, ethics, and the like, from which a lot of these convictions are born, are regarded as secondary, they're not primary. So the focus is on developing analytical skills, your reasoning capacity, and then it stops at that. So nobody can quite bring home their convictions into their day-to-day work. So maybe just to push it on further, related is developing an authentic, influential professional voice. The risk of insulting your intelligence, authenticity is simply aligning your values and experiences. I think that's why a lot of the panelists here have been giving you their practical experiences in answering the questions that were posed to them about the presentations today. I pose a question there: how do you nurture client trust? How do you nurture a credible voice before judicial officers? You've been seeing many of the panelists giving you tricks and ways of getting judicial officers to trust you, and how you can use that to get either judicial favor or have your clients matter believable because of the way you're presented, because of the reputation that you have. The question asked there: is there a tangible role in performative voice? Because you notice that our courts of law tribunals are dominated. I think it comes from, in my opinion, the legislature. But performative voice, people who say things by the script without having any conviction or belief about them. And so, what does that do to your professional identity? Do you really believe what you say? Do you believe exactly what you're saying? The reason that's important is because you're asking a judicial officer to believe something that you yourself do not believe in. Okay, and so naturally it comes out that it is very much harder to convince someone to take your line of argument when you yourself are not quite inclined to it. That's the point here. The influential, I think that's also very clear because this is just how the decisions, opinions, and outcomes. But it's just clarity. That's clear, resonant communication. That's not even if it's an act that you can is learning how to blend the legal argument structure, logic, and emotional intelligence. Just put yourself on the other side and you're able to convince the issue of this by simple basic application of these techniques. How do you do the self-reflection? Some advocates, when the special are starting to document their product appearances, so that they can separate in journal or having their colleagues either report them or, someone was writing down whatever transpired. So you have to go back and you ask all these questions. Natural, easy, feedback, that's how you build your authentic influential professional voice. And the other is the most, it's not quite tangible. This is how you can have relatable experience into your argument. That is, in a way that breaks down the textbook definition of the textbook application of the section. Okay, provision of the law. You will notice that there are several lawyers that do this in their arguments. Okay, as opposed to so all this is just take away I noticed that in many people's presentations before courts of law, it is in the lack of clarity, it is in the scriptism, it is in the that causes judges keep asking questions to starting out and that was the more. Okay. Then I think just to I think at the senior council had announcing the funding of
Hello, Crispus.
yes.
Can you hear me?
Yes, I can hear you.
Yes, you're breaking up. But you're breaking up, and also I'd like to kindly remind you about the time. Time is really going.
Yeah,
Yes.
Speak a lot about this. So let me just wind up this. I hope some people have been able to hear a few things I've been saying, but let me just conclude this. I think senior counsel mentioned about confidence and humility. And as you can see there's a thin line between confidence and arrogance, as you can see. But the balance is that when you're overconfident, you're likely to get into the arrogance space. That's what senior counsel was talking about. But where there's humility without the confidence, again, it's ineffective. I'm sure all of us have had experiences where opposing counsel is not audible. They have very good arguments, strong points, but then not quite audible enough to make their point across. And so that alone costs you the matter. And how to balance it, I think I tried to make a case for that there. It's thorough preparation, assertiveness, but you can still be courteous and respectful. Okay. Then there's a line on ethical advocacy and respectful persuasion. I share a few techniques. Really, you just let your evidence speak for yourself, reduce it to logic, then you have that empathy attached to your argument. In all cases, this beats aggression. I think, again, previously panelists mentioned shouting and, turning that into shouting match doesn't really win your case. Your arguments also, like as I've said, if it's framed around those shared tenets, the values that I previously mentioned, that are integral to the profession, it adds credence to your argument. And of course, examination, again, I think Senator mentioned this, is that you can probe, but you do not humiliate, because there are people who simply set out to just embarrass the other person, assuming that the embarrassment suffices to show that their evidence is not credible. Okay, but maybe finally, to just try to summarize this, the last slide, the few takeaways. First, is that persuasive advocacy, it flows from professionalism and integrity and an authentic voice. And the second is that confidence without humility is arrogance, and humility without confidence is ineffective. Finally, that each of us has the power to model for ourselves an ethical and influential advocacy. Thank you very much. I think I'll end there, moderator.
Thank you so much, Crispus. From his presentation, he has made a strong case on professional identity, and he told us young lawyers, for us to be the best lawyer that we can be, we have to have a very strong professional identity. And again, he asked a very important question: who are we as lawyers? And to answer that, we can focus on being authentic, maintaining the ethical standards, and building a professional voice that will reflect our true character. Now, we've come to the question and answer session. And first, I'd like to thank the speakers for their rich and practical presentations. I had requested the audience to post their questions on the question and answer box, and there are some that have been posted. And I'm going to start with the first one, and this is directed to Senior Counsel, Mr. Odera. Are you with us? Yes. So this is a question that has been asked by Diana Onyango, and she asked to Mr. Odera, Senior Counsel, how do you handle a client who is insistent on the lawyer following their own advice, despite telling them why their way may not work and why? And also, as you answer that, could you also kindly answer the next question? This is by an anonymous attendee who asks, how do you take the facts from your client? This is because how do you take facts from a client? Yeah. Those are the two questions that have been presented that can be answered fast.
Thank you, Otto. I didn't get the second question. Did you ask how do you take facts from clients?
Yes, when a client comes to you and he or she presents the facts about what's happening, so how do you now turn the facts into something that can be presented before court?
Yes, thank you. Thank you very much. To answer Diana, we always come across these clients who think that they know how to address the issue. And many a times it requires a lot of patience, and the way you communicate with them is equally important. I have learned over the years that you take time to listen to them and explain to them that the reason why somebody gets an advocate is so that there can be independence and objectivity in making an assessment of either the strength or weakness of the case. There are some who we call know-it-all, and they will persist. At my level, I am quite entitled to tell a client that since he knows or she knows what needs to be done about their case, probably they need to take their file and handle it themselves. I had an instance years ago. We were handling an election petition, which was which our respective clients could not even sit on a bench together. So I recall having taken a couple of days of hearing, we had to take fresh dates. And when the judge asked us for the dates which were available to us, I happened that I was traveling out of the country for a week. So when I asked for accommodation, that I should be accommodated the week after I come back, my opponent's client came and started shouting and saying, no, I am just delaying this matter, and told his lawyer, don't accept this thing being put too far away. The lawyer calmly closed his file and gave the client the file and told him, since you know better how to progress this matter, why don't you take over your file and I'm walking out of this case? It was at that point that the client calmed down and appreciated that at the end of it all, the lawyer was not his mouthpiece. So the way you handle it, but ultimately with the aim of advising the client that the reason why they came to you is because they thought you could add some value. But since they seem to know how to handle their case, probably you might not be useful. And depending on how you say it, they might. Can you hear me? Somebody saying they can't hear me.
Oh, I can hear you, Celia.
Okay.
I can hear you.
Okay, thank you. Yes. So once you explain to them that the reason they came to you was because they must have thought or seen that you could add value. If they are of the view that they know how to handle the matter, then they can take their file. More often than not, if the client has confidence in you, they'll get the message. How do you take facts from clients? This is usually an interesting exercise. You first must have the client narrate the facts as they know it. And oftentimes there will be gaps. Feel free to ask the client whenever you recognize a gap, you ask the client. After all the client has said what they have to say, and hopefully they have shared documents with you, compare their version, their oral rendition of their case with what is captured in the documents. And always advise them that you are on the same side. All you're trying to do is to prepare them for questions which probably the other side may ask. So in that way, they don't get suspicious of you. I recall one time a client asked me whether I was representing him or representing our opponents. And I told him, I'm representing you, but I'm merely preparing you what our opponents will ask you. And we formed a very, very good working relationship. As always, clients will come and give you their version of the story. And before I hand back the mic, let me share with you very shortly when a client asks you for an opinion, a written opinion on a matter. Always set out the facts as the introduction of the opinion. The facts as you understand them are as follows, and you write them down. The documents you've reviewed are as follows. You write them down. And then you say, based on the material I have examined, this is my opinion. Because clients have a way of, if you dive straight into the opinion without setting out the facts, later they'll accuse you of having misadvised them. And the truth of the matter is that probably they didn't tell you the whole story. So you must always capture the entire instructions on that opinion and the documents you have reviewed. Thank you very much.
Thank you so much, Senior Counsel Chodera, for answering that question. We have another question that has been asked, and I'd like to direct this question to Elsie. Elsie, are you here? Are you here? If Elsie is not present, then Alex, are you present with us?
Yes, I'm here.
Okay, so it's the next question that's asking, with the move to virtual court sessions and time caps on oral submissions, how can an enthusiastic orator advocate in court? And are the grand, persuasive, and oral submissions dead?
Okay, so I'll do my best trying to respond to that. And I think I'll share some experience with what we're having in Uganda. Our courts have mostly gone electronic, especially in CBD, and there's electronic filings of all documents, albeit that the hearings, most of them are physical. You'll be required to attend courts. There's just a few courts, for example, the tax tribunal that has adopted these oral hearings, and they can handle the mentions on the online platforms, and then the hearings will happen in open court. I think it's not lost because being a good orator and being able to submit will appear both in your submission and also your written submission. And moving online is just but a medium within which you communicate. We are moving towards having this. We're pushing for this on some committees in certain courts where we are moving towards this. We're asking the judges, can we have oral hearings? Because we take a lot of time to reach court, and you lose a lot of time, unbillable time, to get to the court. And some courts are far away from where our offices are. You have to travel 5 hours to go up country, or 8 hours, as the case may be. So when you look at the benefit that you will get from this oral submission that you're going to make physically, probably it may be outweighed by having an online hearing. But like I said, I think for me, my take home here is that you moving virtual doesn't take away the skill you will be required to make your submission online. And also, probably the others are just, by the ways, you have a good network. We see you have faced some internet challenges on this call. I think if you put those if you align those, you'll be home and dry. A grand, persuasive, and oral submissions dead, they can't be dead. when you look at our appellate courts, in the Court of Appeal and the Supreme Courts, even when parties are required to file to file written submissions, they'll be required to appear in court to highlight their submissions. And it's at that point that the judges will pick up. You can be allocated, say, 5 minutes to highlight your written submissions, and the case could be won or lost at that. So I think there's still a lot, even when you go virtual, to do in terms of oral submissions. Thank you.
Thank you for that. And also, in the interest of time, you will allow me to rush this thing. So the second last question has been asked, and its preparation has been done, and everything is on the right track. So as a young lawyer with little experience, how should I handle unexpected questions during court hearings when I'm unprepared to answer directly? This unexpected question has big impact to the case. This question can be answered by any of the other panelists who's remaining.
I think I will give it a shot, and I will ask maybe one of my colleagues to supplement. I think we see that increasingly, and I think some of our best judges, especially in the High Court and the Court of Appeal and the Supreme Court, ask these hard questions because they want to save time. They want to save time of the lawyers who know they have bad cases. They want to conclude backlog cases, and sometimes they ask those questions that the lawyers may not be prepared to answer. What we see increasingly is that you have to remain calm when that is done. Sometimes you can ask for a standover of the matter. Other times you could, and actually before I leave that point, most of the times when you're unprepared for those, we have seen judges allowing lawyers to have the matter stood over for maybe for 30 minutes or for 1 hour for you to ascertain the facts or to probably respond. But sometimes when it's just a mere wastage of time, there are some cases where the lawyer knows there is no defense. The judge is asking, show me your defense. You have been in court for 5 years, there's no defense. So in such cases, even you may know that the rope is done and that is the last leg they are on and you're going to fall away. But sometimes you could consult with your clients. We have seen cases where you can consult your fellow colleagues at the bar if you are unprepared to answer maybe a specific legal point. But I think ultimately, adequate preparation. And it could have been mentioned by any of the panelists here that when you are litigating, place yourself in the shoes of the other lawyer. When you're doing research, don't only research on your own case. Look at the strong decided cases on your side of the case. Look at the other cases on the other side, because they could place a Supreme Court decision before you, which disagrees with you. And if you're not prepared at that point, your case could fall away. But if you're adequately prepared, even those unexpected questions, you could create a narrative, or you remain aligned to your strategy and answer the question that has been asked. I think I'll submit that and ask my other panelists maybe to chip in.
Otto, if I may be permitted to just say something on that.
Okay, very briefly, kindly.
I'll keep it as short as possible. The resounding overarching point on responding to difficult questions in court is adequate preparation. No one is going to ask you a question that has nothing to do with the case that's before the court. So you will find that you may not know what question is going to be answered, meaning you cannot read in preparation for a specific question that the judge may pose. But what you have control over is the facts of the case, because you know them. You know your case, and you also know the other side's case. So read as extensively as possible, both on the facts and on the law, and you will be able to adequately answer any question that has been asked of you. Of course, in the situations where you asked a question and despite your preparation, you're unable to answer it, find a way to buy some time. As Alex has said, you can seek a standover. Sometimes you can even seek an adjournment if what has been asked of you is something that requires a lot more time to be able to answer than just a short standover. Yeah, so that's it.
Oh, thank you for that. And now, as we wrap up, senior counsel, there is another question that has been directed to you, and after you've been able to answer the question, I will kindly request you to give us a take home so that we can work with your words, with your final word after this presentation. And once senior counsel has done, we will now be able to wrap this up in the interest of time. So this is the question that has been directed to you from the question and answer platform. So senior counsel, how do you handle a bad case or address the client where your case has not persuaded the bench, especially where the other party has been awarded costs? What are the core norms you advise we adopt to the case when the case is not practicable, appealable with success? This is a question from Mike.
Yes, thank you. At the beginning of my conversation with you, I did say that there is a duty cast upon us not to manage our clients' expectations. So, how you manage those expectations by being honest and candid with them at every step of the way. There are times when they first come, your view on the matter may be taking a certain position. And then as the case progresses, probably more material has come your way, or the case is partly heard and you've seen the performance of the witnesses. It's important at every stage you refer to your previous opinion and come and advise that that opinion was before either evidence was taken or before these other documents were supplied to you. And if that materially affects the case, then you must be candid to tell your client. And when the case, the sum total of it is that it's a bad case, never shut your door to discussing a negotiated settlement. And there are times when your opponent may also be a difficult opponent who wants their pound of flesh. In that case, you, as if you persist or you make the determination that the case must go to its conclusive end, then you must work towards trying to mitigate your client's exposure. There are cases which are not purely driven by law. Some are egoistic. I do recall one time handling a case, a community case, where two clans were fighting over some ancestral shrine. And it wasn't a question of who's right, who was wrong. It was a question of we fought it out, and it's the court that gave you people that shrine, and not we people ceding it to you. So in that particular case, it means a lot to them. Assist the court in terms of putting forward your client's case, however hopeless the facts may be, and let the court make that determination. And that's why I spoke earlier that we must also learn how to take both wins and losses. But the most important thing, keep your client appraised of the case as it unfolds. Otherwise, they'll one day blame you and tell you that had you advised them earlier, they may have taken a different course. So thank you very much. I hope that answers the question.
Oh, yes, it does. It does. And now we proceed to wrap up the session because of time.
Yeah, thank you so much, Mr. Otto Nduva, for that very wonderful, insightful session. I couldn't end this session without thanking you very much, Senior Counsel Church of Era, for your very wonderful keynote, and most of all for availing your time in your very busy schedule of the day to come and mentor us. It's been quite insightful. We are really, really grateful from the bottom of our hearts here at the Secretariat. And we look forward to seeing more of you, Senior Counsel. When we invite you, sir, do not get tired of our invitation. We want to draw and learn from your wells of wisdom as much as possible and get better at our craft. To you, Timothy, Alex, Elsie, Jebra, Crispus, and Mr. Nduva, really would like to thank you for availing your time and being part of this very wonderful session. It's been quite captivating and mind-blowing, as you can see from the questions and comments. We are sincerely very, very grateful and look forward to hosting you more and more. Now, I'd like to hand it over to you, Mr. Nduva, to give us your final closing remarks in 1 minute, and then we'll close the session. Thank you.
Thank you, Gabriel. And my final remarks as we come to the close of this session, I would like to extend my sincere gratitude to each one of our speakers, Chato Odera Senior Counsel, Alex Ntale, Debra Kambole, Timothy Lugaizi, Crispus Mutabuza, and Elsie Michelle Irakoze. Thank you so much. To our colleagues who are joining us from across East Africa, thank you for your active participation, your thoughtful questions, and your commitment to grow as young lawyers. Again, confidence is built, not born, and every effective advocate was once a nervous one. So thank you all, and I wish us all the best as we continue with our legal journey. That's all, and goodbye.
Bye, and thank you so much. We can now exit at leisure. Blessed evening. Thank you.
Bye, everyone.